her to pray for us. And Senator Campbell, if you just press the mic, I will allow you to be able to. And now you can speak.
Thank you, Mr. Chairman. It is my pleasure. The mic seems to be falling at me though. Let us bow our heads. Heavenly Father, we invite your divine presence in this meeting this morning. We ask you, Lord, to be with us throughout our deliberations. Help us to work diligently and creatively. Help us to exercise the best of our intellectual minds. To the good of our people, in your name we pray. Amen.
Thank you very much, Senator Campbell. This morning's meeting, we will have to finish by midday, okay? Because at midday, the position is they want to do a training session for the use of the mic. But I think we only have one presentation for Jamaicans for Justice, and therefore we want to thank Jamaicans for Justice for coming. I think we put them off last time, and they have a very fulsome presentation which should take us the better part of the time we're here. Hopefully some time will remain for us members of the committee to discuss how we go forward. I think we may have maybe one more meeting where we decide and just report. You see, we have a template. Because the truth of the matter is 3 short bills. We just have to make some decisions as to what is agreed, all right? So, any apologies for absence? No? Senator Senator Lambert Brown had indicated he would not be here. Welcome to the CPC, the law reform, and also MOJ. Who else is here? Attorney General Chambers, all right? So without further ado, no, may I just say also, you know, the minutes, unfortunately, I didn't see them. They were sent by email, but I must admit I didn't read them as yet. So we're going to put that off also, the reading of the minutes and confirmation. So without further ado, we're going to ask Ms. Jackson from Jamaicans for Justice to say who is with you and then to start the presentation. So turn on and then I will allow you to be able to speak.
Good morning, members, and thank you so much, Minister Chuck. I always ask the persons with me to introduce themselves.
Sorry? Yeah.
Good morning, everyone. I'm Jade Williams. I'm the Policy and Advocacy Specialist at Jamaicans for Justice.
Go ahead.
You proceed.
All right. Thank you so much to the Joint Select Committee for accommodating Jamaicans for Justice as we make our presentation. Minister Chuck rightfully said it's 3 short bills, but we recognize that it's 3 short bills that will have far-reaching impact in different ways. I want to start by quoting some wise words that were spoken a few years ago, if you would allow me.
Sure, go ahead.
When a judge, having listened to all the facts, looks at all the aggravating factors, the mitigating factors, the age of the offender, and the nature and gravity of the offense, there is no way it can be consistent because all the judges have different education, upbringing, skills, knowledge, and experience. The person who spoke those wise words went on to say, moreover, I wish we could move away and get the public to move away from the retributive purpose of sentencing to what we're pushing in the Ministry of Justice, restorative justice, where we hope that the victim can be brought to the sentence process to forgive and the offender can admit his wrongdoings. I'm not sure if Minister Chuck recognizes those words.
Not really.
But he spoke them. All right, so I just want to bring into context the purpose of sentencing and whatever decisions that were taken as a society, as the Joint Select Committee, that we have to consider the varying factors that must be looked at as we, really examine the issue of mandatory minimum sentence and the implications of it. Now, we agree that when we look at the purpose behind mandatory minimums, and generally any sentencing, it is based firmly in factors such as retribution, deterrence, and denunciation as crime prevention and crime control. And I'm just putting some things into context before I go into the recommendations as we outline them. And what I will do as well, for ease of reference, is to make pointed reference to the recommendations and the pages. So you won't be lost, rest assured. All right? Now, while the rationale for high mandatory minimums or sentencing may be at face value, they seem reasonable. Our research has shown that the use of mandatory minimum sentences does not necessarily achieve the intended goals that one would want. So I think we have to be looking again at the implications for human rights. For example, prison overcrowding, other breaches of human rights that may occur, and unjust sentencing for vulnerable offenders. And we took the duty and the care in listening to every single presentation that was made before the Joint Select Committee before. And I think we heard some recurring themes. For example, the issue of child offenders and those recommendations. Now, we're setting the context for us to understand the reasoning and the rationale behind JFJ's position. For example, when we look at the matter of prison overcrowding, we have to consider what the implications may be when we have manifestly high mandatory minimums. We look at the matter of pre-trial detention and so on, and we have seen the concerns that have been raised before. The question we ask, when we have these levels of mandatory minimums, what are the implications on an already overburdened prison system? That's one. We've heard the Ministry of Justice championing restorative justice, championing rehabilitation. Within the context of our children, youth offenders, we ask ourselves, again, what are the implications? I also want to caution the members here that when governments have good policy decisions and legislative directives, we should not move away from the course that is being taken. The Child Diversion Act, and I know the minister mentioned, for example, he's going to be reviewing some of the matters that can be brought before the Child Diversion Office. We'll look at Xavier Main, our state minister in national security. I believe last year he made mention of the new offender policy that is focusing again on rehabilitation. We have heard the partnerships with several universities, one of which I have the privilege of lecturing part-time, and the implications of boosting the skill sets of our youngsters. Again, I ask, when we look at the issue of mandatory minimum, how is it undermining some of these efforts that the government rightfully has been moving towards? The last time the committee met, July 18th and 26th, and I think before that, you also heard several concerns about the possible breaches of the international laws and protection of the treaties and so on that we are signatory to. And several conversations would have been had around the Tafari Morrison case. Now, from JFJ's perspective, we look at several aspects in terms of the international treaties to which we're signatory and the implications of that. In our presentation, we're going to be talking just briefly around the ICCPR and Article 14, which speaks to the right to fair trial. Now, the last time we heard from the Office of the Director of Public Prosecution, for example, and we had anticipated that this would come up, the Section 42K in the Criminal Justice Administration Act, which speaks to one's right and ability to seek an appeal. Now, when we look at mandatory minimum and the fact that as the bills are currently proposed, it doesn't allow for judicial discretion or sufficient judicial discretion. It's a cause for concern. Now, what we're saying to those who can't afford it, that based on the limited time that you have, 14 or 21 days, I think, within which to make an application to seek an appeal to be pursued, when we look at the fact that legal aid, for example, it's not going up to the level of Privy Council, then we ask ourselves the question, what are the implications? Are we passing laws that ultimately will see those who can't afford an attorney, those who can't afford to pursue an appeal process being left behind? Are we legislating a process that may very well deny access to justice for those who are vulnerable? So yes, Section 42K exists, but we must look at the parameters within which such an application would be granted. That's another thing we're asking the Joint Select Committee to consider. And again, we're just setting the context before we get into specific recommendations. The increased strain on the judicial administration. We heard, for example, Justice Sykes speaking that the parish courts have finally achieved backlogs no more, and that's an important achievement. And Justice Sykes had mentioned that the higher courts have improved in terms of how efficient they are. Justice Sykes speaking a couple months ago, and I believe another member from the judiciary, I think Patrick Brooks, I stand corrected, they mentioned and cautioned that with an implementation of higher mandatory minimums, what would an implication mean for the court backlogs? And for those who are listening, because I know the Joint Select Committee understands the implications of it, but for those who are joining us on the YouTube PBC live streaming, when we have higher court backlogs, it means that the administration of justice is delayed for several matters. When we look at matters being dispensed of in the court system, can you imagine when we have this level of high mandatory minimum, more people challenging their sentences before the courts? So the Supreme Court would be overwhelmed, and of course the Court of Appeal will be overwhelmed. These are things that we must look at. So we understand that members of Parliament...
No, you can speak now. You want to interrupt?
Yeah, I do want to interrupt. I do want to interrupt if this mic and I
Just leave it. Just leave
I always
it.
wanted to be a rock star. Mr. Chairman, I'm having a difficulty, Ms. Jackson, with some of what I consider to be conclusions drawn without evidence. And I'm very careful as a legislator because your job as civil society and as an advocate in the areas you advocate for
Yes.
and in is to drum up interest, drum up support. And to the extent that you do that, you like to use adjectives and superlatives. I have a problem with that as a legislator because I don't know on what basis I would assume that more increased use of mandatory minimums equals more people challenging their sentences to the extent that the court is going to be overwhelmed. I don't think there's a basis for saying that. Certainly, I can accept that it may increase the number of persons challenging sentences, but how do we get to the court is going to be overwhelmed? I don't see how you make that jump at all. So I want to hear the gravamen of your submission, but I don't want us to get into a situation where it is exciting a point of view that you haven't grounded. So I just ask you to bear that in mind as you're talking to us in terms of what we must consider, okay?
Thank you, Member. But respectfully, we have done research in other countries as we speak, and with the greatest of respect, what I did earlier was to quote the Chief Justice.
Sorry, could you... I turn off mode. Turn back on yours, and I'll let you in.
Was saying respectfully, what we have done is research in other jurisdictions, and also what we did earlier was to quote the Chief Justice. So I don't think we're speaking or making comments from a place of an uninformed perspective or using language that may simply generate interest. What we're saying is based on other jurisdictions, it's a caution that we're making before the Joint Select Committee.
President.
The very information that I would want to hear you present, not the conclusion that you have drawn, but the evidence that you have discovered in other jurisdictions that would convince me of the conclusion you're drawing. I can't accept your conclusions. I have to sift the evidence on my own. And so I'd be grateful if you could point out as you make those conclusions what's the basis for saying so. Okay?
All right, Senator Binns.
Thank you. Thank you, Mr. Chairman. Mr. Chairman, I understand from where Senator Golden Campbell is coming, but the norm here is that we allow the presenters to make their presentation and we only interrupt them if we need further clarification. I think, certainly for my purpose, I would want to hear the full presentation, and then there is an opportunity for question and answers as well as to seek further clarification.
All right. I think that they're good suggestions, Senator Binns and Senator Campbell. We allow you, Ms. Jackson, 10, 15 minutes to do the first part, or how many parts you have?
We would set context for another 10 minutes maximum and then go into the specifics,
And
if
then-
you would allow us.
Okay.
And that's another 10
So
minutes.
make a broad presentation, and then we'll ask questions and that.
Sure.
And then you can go into one or two other specifics, okay?
All right, thank you so much.
I think Senator Campbell's position is we didn't want to wait half an hour before we ask questions, because the point really is that after you make the first 10, 15 minutes, then let us interrogate some of the points you've made.
All right,
okay?
thank you.
Good.
To be the only presentation today, right?
Yes, yes, yes.
So, and it's a,
No,
sift
to be
through
fair,
it's
I
a substantive
didn't-
one, so I don't want the points to be lost
No,
along the way.
and to be fair, the Jamaican Justice has done a comprehensive review of all the bills. So we will just allow the interrogation to just after her preliminary presentation. I don't know if you need to hold the just allow it. Does it after a while
It would, okay.
it falls way down, or it stops at a certain point? No, man,
Yes,
this
it
don't
does.
make sense. I mean, mine stops here, so it's okay.
Maybe that's better.
But yours, I mean, mine. I don't know. It seemed to. Your. No, but your mic. Does it flop right down? No, but I don't understand this mic. Tell the marshal to tell the people these mics. No, there must be a way that the mic stands up. Huh? But it not look good at the beginning, man. I mean, this one is okay. You mean they give me a good mic? I see what you mean. Ms. Jackson, please continue.
All right, I'm not sure if this is, it's not the most comfortable hearing. Oh, perfect. Thank you. All right, so the other issue, and again, this is a principled position here. We have made it very public that we do not support mandatory minimum of this level. And I think for those listening in, mandatory minimum already exists in law for serious offenses. It's there for murder, it's there for rape, and I want to be very clear that JFJ is not against mandatory minimum, because if you read our proposal, there is actually one that we have called for mandatory minimum to be higher in instances of rape. I want to be very clear that we're not against it.
To the best of my knowledge, it's not mandatory for rape.
You have to prescribe, there's a prescribed minimum there.
No.
For 15 years.
No, it's not mandatory. It's, is that SG? We don't have a mandatory for rape. Huh?
Under the Sexual Offences Act.
No, it's not mandatory. For child, I know for child, there's one for child molestation. But to the best of my knowledge, rape is discretionary. SG,
Under the Sexual Offences Act, to my knowledge.
No, it's up to
there
life
is.
imprisonment. There's no doubt, but to the
life
best of my
imprisonment,
knowledge.
15 years minimum must be served. That's my understanding of it.
Is that so, technical team? 15 years for all rape cases? We'll check on that. Okay, sorry, but just go ahead.
Sure, but the point that we're making is we're not against it in principle. We're against it being manifestly excessive when there is no judicial discretion. Because from our perspective, and we have said this publicly, and I want to reiterate it, and I hope there is no offense that is to be taken, but we do believe that the separation of powers is being violated in that context when we tie the judge's hands to an extent that they cannot consider the unique circumstances of each case. And that is something we have made pointedly clear in public. So that is something that we caution the Joint Select Committee to consider, that even if we go ahead with the mandatory minimums as we have it here, what we're saying is that there ought to be some safety valve that is inserted. And when I go through the recommendations in specific details and make mention to other jurisdictions, we will see some of those recommendations.
Can we allow our members then to deal generally with this broad framework that you have about the mandatory minimum, okay? And then we can go after that in the specifics. First of all, bear in mind, Ms. Jackson, that when we're dealing with murder, I mean, just in 1993, I think it was, we decided to move murder to capital and non-capital. Before that, it was mandatory death penalty. You remember? There's still a call by 90-odd% of the Jamaican population for murder to be imposed, and it is still on the statute books. Agree? Now, for capital murder. So it is still a possibility, put it no stronger than that, for capital murder. The question you ask, and this is where we are, if you're not going to impose capital murder, what would be wrong with a very stern, strong, high mandatory minimum? Because the alternative is death. And most persons who committed capital murder would be considered enemies of society. Put it no lower than that. And the victims and the families of the victims and many Jamaicans would want to see that person out of the way, preferably, they say, by death. But what would be wrong to say the mandatory minimum, as they do in many countries, life without the possibility of parole? But we are saying life, but you serve at least 40 years or 50 years. So in other words, what we're saying, we have to send the signal, the legislature has to send the signal that this is the appropriate remedy to ensure that that person leaves and never have the possibility of returning to the society to be a menace. Then there's a safeguard. The act, the plea bargaining and the negotiation act. Murder has a wide spectrum. It's not, no murder, all murders are not the same. There's a rainbow, of gravity in terms of the nature and gravity of the offense. So those cases, in fact, which could be rage, emotional charge, and the offender frequently regret afterwards that it occurred because it's a spur of the moment. If they plead guilty, the likelihood is that the discretion is there for the judge. It's not mandatory. So we have not excluded the Plea Negotiation Act. So once there's a plea of guilty, the mandatory minimum doesn't apply. It's a matter for the court. But we are looking at those egregious cases where the case is fought, the evidence comes out, the mandatory minimum is imposed. Even if they plead guilty, if it is really egregious, the court still has the discretion to impose a very high penalty. Fine? So why do you say that the separation of powers have been breached or is being interfered with? Or why do you think the legislature, bearing in mind what is happening in the society, shouldn't send that signal?
Thank you, Member Chuck. There are several things that you said earlier, that there is a range of offenses that will shock the public's conscience. And when we look at the proposals that are being made, you don't see that range, I think, sufficiently recognizes that some things can be so egregious that it sends the signal that this particular act is something that we're not standing for. Everything is manifestly excessive with what we have here being proposed. And we have a section that we suggest that we can lower some of the levels where we say, yes, murder is wrong, but you start, for example, at 25 years. This particular case, based on these aggravating factors, do shock the public conscience, so you start at a higher year. What you have, the things are so close that the intent that you have articulated, I don't think it is being achieved when they're so close together in terms of, I think, 35, 45, and 50 years. And again, there are implications when you look at the manifestly excessive mandatory minimum, in our opinion, when you have, for example, 50 years for capital murder, I think 45 years for non-capital. What is the distinction with just 5 years in between them? What exactly are we sending to the public? That offenses relating to capital, it's something that is so egregious that it needs a higher level versus non-capital.
Ms. Jackson.
Yes. In our opinion, I'm saying,
no,
Minister
Ms. Jackson,
Chuck,
within the openness to the public, to just throw it down your throat, you know.
Absolutely.
We open it to the public for you to make some recommendations.
Yes, and we have one on that.
For us to be persuaded that instead of 40 years, it should be 30. You get me?
Sure.
But it is not for you to quarrel about the 40 and the 35, but to make some recommendations what would be more appropriate. You're with me? Not that, and why?
No, I'm just saying we do have it in
So
a particular
that is the reason why
recommendation.
we decided to come to civil society and to the public. Because let me tell you, there are others out there who feel that these figures might, in fact, not only appropriate, but be too low. So it is for you who you're on the other side to persuade us that maybe instead of 40, adjust it to 30 or 35. Instead of 35, adjust it to 25 or 30, and give us why you feel that would be a better idea than what we have, okay?
Absolutely, Minister. And if you could turn your attention to page 10, recommendation 4.2. Recommendation 4.2, page 10. Our legislative proposal, and we looked at other jurisdictions. What we're saying is we do agree that the public and society's concerns must be considered. I think we're on the same page with that. Crime rates are exceptionally high, and we should send a signal as a society, and certainly through Parliament, that there are certain things that we will not be standing for.
There's only one thing I'll had a look at very quickly.
Yes.
Start from the position which was passed in the Parliament, where being in possession of a firearm is 15 years, minimum.
Yes.
How would that fit, where in fact that firearm is used to kill? So not only are you imposed 15 years for being in possession of the firearm, but you will agree with me that to use 15 years for the murder with it would be inconsistent.
Which is another point that we made in our proposal, that what we're saying to Parliament, I think it's in the public's interest, and certainly for consistency, that we take a look very broadly on the serious offenses rather than looking at things in piecemeal approach, because that very question that you asked just now is a cause for concern for us, that when you put something mandatory minimum for firearm in that regard, now that we're having a conversation here, it means that we automatically are saying, because it is 15 years over here, it makes sense that it must be at a particular level. And I want to caution us that remember when the firearm bill was proposed, it wasn't 15 years the Parliament had. It was automatic life imprisonment. That was what was actually proposed
That is
earlier.
it from the 70s, you remember
No,
that?
no. Last year when the bill was tabled for firearm, before it was passed, it was a mandatory minimum automatic
No.
sentence, of life. You can check the record. Thankfully, when it was finally passed, it was reverted to 15 years minimum being served and then life imprisonment for the maximum. So I want to challenge us to take a look at that record when we look at the firearm. But the point that we're making is it is important that we look at the serious offenses and ensure that, yes, we're sending a signal that we will not stand for high crime rate, but we should ensure that there's consistency in law, because one decision over here will impact the decision of the Joint Select Committee in other ways. That is the caution that we're also making. I think I may be rushing over some aspects to make a point, but if you look through our recommendation, there are other things that we're also saying to the Joint Select Committee that maybe it's not for you to make the decision now, but I think we should be looking at other jurisdictions, for example, that has a sentencing commission of sort, wherein it's still over by the judiciary, but there are actually expectations, like the sentencing counts that exist in the UK, not the model that we're proposing. You have it in other jurisdictions, Australia, New Zealand, and so on, that we look at the sentences that are being imposed, we look at whether or not it's working, and then we make recommendations accordingly. That's one model. But certainly as a starter, we're just cautioning the Joint Select Committee and the House of Parliament that we should ensure that we're not looking at things in piecemeal, because it can have implications for the types of laws that we're passing.
Colleagues, anyone want to raise any points now?
She wanted to clarify or seek clarification from the members on the Plea Negotiations and Agreement Act vis-a-vis what the provisions are in the Criminal Justice Administration Act regarding plea bargaining and the guilty plea. I think...
No, once the plea negotiation, Plea Agreement Negotiations Act allows the offender, the attorneys, to negotiate with the prosecution a guilty plea and an appropriate sentence.
Yes.
The sentence can be recommended to the judge. The judge can accept or reject. Now, the judge, if the judge, let's assume that there's an agreement. The likelihood is that the judge would accept. But if the judge refuses and say, no, I don't agree with 10 years, it has to be a higher penalty, then the defense can refuse and withdraw and say we're going to trial, or we ask for another to be tried before another judge. If the judge says the sentence is too high, I want to impose a lesser sentence, the prosecution can withdraw and ask for it to go to a trial before a different judge. So you see, the provision is in the Plea Agreement Act for that to happen, so that the ultimate arbiter would be the judge. Okay?
Yes. So our contention with that is that the plea negotiations agreement is a separate process from what we're considering under the Criminal Justice Administration Act, which is simply entering a guilty plea. So if you go under the Plea Negotiations Act, you have excluded yourself from being able to come under the provisions under the Criminal Justice Administration Act.
That is correct.
Right. So we're saying that the discretion that we're asking for is not that discretion that's under the Plea Negotiations Act, which is a separate process from simply entering your guilty plea.
No.
Which would give you a discount under the current provisions under the Criminal Justice Administration Act. So what we're saying is that is a separate process. And in this process that we're considering, we want to see the judicial discretion reinserted into the section.
Well, once you plead guilty, no, I must tell you, and as members of the committee, I don't support that particular provision in the Criminal Justice Amendment Act, Section 42.
Yeah.
Forget.
Yes.
I think guilty pleas should be associated with a bargaining between the defense and the DPP so that an appropriate sentence can be agreed on. And the reason why I'm saying so, it avoids the possibility of the prosecution appealing. Because if the judge imposes a sentence which is, say, less than what should be imposed, then the prosecution may appeal, as it now has that provision to do. So my view is that all guilty pleas should be followed by a negotiation under the Plea Agreement Negotiation Act. I keep mixing up the terms, right?
But I think, Minister, the point is that currently, based on our reading of the two pieces of legislation, it doesn't reflect that view. They're treated separately. So while under the Plea Agreement and the Negotiations Act, it speaks to a bargaining process with the prosecutor, and there are certain provisions that the judges may agree or disagree, and so on. Under the Criminal Justice Administration Act, Section 42K, I think D, my apologies,
42C in terms of
42C. No, okay. Under Section 42, let me keep it broadly. The issue that we're having here is that the judicial discretion isn't there because there are certain procedures that one must follow. And I go back to the point about raising the mandatory minimum. When you raise the mandatory minimum and you have the fiction of life now being what it is, 50 years, and then we start looking at the discount. A discount being applied means that you will not go down a particular amount. That's the first thing. And then when we look at that particular section referencing Section 31B of the Offences Against the Persons Act, which now moves up to 30 years, we're saying irrespective of the circumstances, the judge cannot go below 30 years.
Right.
And that is our contention with the guilty plea consideration.
Right, Ms. Jackson, may I just say, and members of the committee, what Ms. Jackson is saying is quite correct. And indeed, my technical team will tell you, one of the proposals is to delete that section 42A, you say it is? In truth, I must tell you that
42C, 42DE,
one of them.
Yes.
So that once there's a guilty plea, then you go straight to the Plea Bargaining Act. The truth of the matter is that that amendment, Criminal Justice Administration Amendment Act of 2015, I supported it in Parliament at the time. Former Minister of Justice, Mark Golding, had passed it, which I thought was a good act. But when I tabled the Plea Negotiation Act in 2016 or 2017, I realized the inconsistency. I had indicated to my technical team at the time that we would delete that, but the Law Reform Department asked us to allow it to continue and let us see how it works. It has worked in two ways. It has worked well in many cases, but there are many cases, in fact, where the sentence is imposed and the victim is not even aware because there was no negotiations. The person just plead guilty, the judge imposed a sentence, and sometimes the victim asks, what happened? What happened? Well, you see, the plea negotiation allow the prosecution to interact with the victim as to what would be an appropriate sentence. And that is why I'm looking at deleting that section of the Criminal Justice Administration Amendment Act. Okay?
Thank you so much, Minister. Should the committee not agree with you, though, we do have a legislative proposal that will insert some judicial discretion, and it's there in our document for consideration still. So we certainly appreciate that. And I think in keeping with the principle and the spirit of what we articulated, that's the reason for us saying that we should consider again the years that are being proposed. And we did not shy away from it because I recognize that several of the presenters before, and I understand their positions, opted not to say this is what we would counter the Joint Select Committee with. So we looked at other jurisdictions, and for example, rather than certain years being proposed, we just put some years on it, but not to the level that we have here with the bills. So I hope that could be considered favorably. And if the
Where is that
committee-
specifically in your, sorry?
Page 10, the legislative, let me give you the exact page.
You go ahead,
No, I was just asking for her to point us to where those recommendations
Right.
are so that we can follow.
Page 10, and I'm not
page
seeing it on
11.
page 10. Page 11?
Page 11, there is a section that says we should reduce the proposals for the starting points that the bill was proposing.
So where originally we had 15 in the principal act now, you would recommend 25 instead of where we have 35. I think we have
Yes.
35. And in section 1CA, it has 20. We are moving that to 40, I think, or 45. You are recommending 35.
Yes,
And in 1CB1, we have 15. You would like to move it to 20. I think we had moved it to 30.
yes.
Right. And in B2, we had 10. You would move it to 15. We had moved it to 25, I think, something,
Yes.
something like that.
So we are asking for the committee to have some middle ground in its own objectives, but again, in keeping with the things that we were cautioning about earlier, those possibilities, we think with the insertion of the safety valve still, we can still maintain the human rights standards.
Could you
and-
help the
and so on.
committee and tell us why you think that these figures that you have are appropriate?
What we did was to look at the context that at the end of the day, these are simply starting points, right? Let's be very clear. Starting points would mean that based on the aggravating factors of a particular case, certainly the judge would go up. But when you have a starting point of, say, 35, 40 years, how further up the judge will be going in certain cases? And again, what we did was to also look at other jurisdictions to get a sense of what were some of the starting points that they have, but considering our reality to have a middle ground being struck. So those were some of the thought process that went into it. So, for example, when you heard us talking about the guilty plea issue, you realize that it's not absent from the conversation that is being had here with the starting points. Everything correlates and they're interdependent in terms of how the law is going to be reasoned through. So those were some of the thoughts
Senator
that
Gill.
we had.
So what I'm understanding, Chair, is that she is seeking to widen the threshold to allow for a better room for negotiations.
Absolutely.
Can you tell us, in other jurisdictions, the extent to which their threshold has worked?
Yeah, that's the question, Senator Gale. Worked in what way? Because one of the challenges that we're having, and even responding to Senator Golding's question earlier in terms of research going into a document, for example, we look at UK's model. UK has life without parole, not something that JFJ would necessarily recommend. So there are certain variables that one would have to consider to get a sense of working what way. What I can say, though, Senator, that the United States, for example, mandatory minimums, even for juvenile offenders, were seen as some sort of panacea to crime fighting. We're seeing the United States, that is not even a signatory to the CRC, moving away from
Being a rainbow, for the really egregious, it allows the judge to impose at a higher level.
Yes.
But at a low egregiousness, if there's such a term, then you don't necessarily want to impose it at that higher level of 35, maybe 25. The circumstances might justify a lower sentence than 35.
Yes.
So the position which you see, to put it for you is that because the nature and gravity of murders has a wide band, it's better to start at a low threshold for the really less egregious,
Yes.
to life imprisonment without parole for the really serious egregious act. So that would be your, I'm saying, put it for you in that way.
Basically, serve the longest sentences for the most heinous crimes.
Right.
Just to switch focus, and my apologies, the conversation took us all over. We appreciate
No,
it though.
recover. You can recover now.
We used to do debating in school, so we're used to the pressure. Thank you. I want to turn our attention to recommendation 3, which is
What page?
starting page 6, and it goes up to page 9. And this is the section that deals with children and mandatory minimums. I think the committee is very clear. Jade has spoken publicly, so have I and board members on JFJ's position on this particular matter. And we do not support mandatory minimums for children. That's our first option. But like most of our positions being made before the Joint Select Committees on most bills, what we do is to articulate where our position is, but try to negotiate to a middle ground that perhaps can satisfy the Joint Select Committee, Parliament, Society, and human rights standards. So before I get into that, though, the last time the committee met, and I remember the exchange with Madam DPP, and it was a very good exchange, and I think it was Minister Chuck, you were probing the issue of children who may come under the influence of adults and the implications for those adults. And let me say on record, we do support that where adults engage children in these types of activities, the adults should bear the burden of responsibility. And I don't know if the law doesn't speak to it sufficiently. That is something I think the Joint Select Committee, through its drafters, should really consider. And it is in keeping with the Criminal Justice Suppression of Criminal Organizations Act. That's the anti-gang legislation. And I just want to say that Section 14 of that piece of legislation is instructive, because the legislator does recognize that there are instances where a child is forced to participate against their will. And in fact, under that legislation, in so recognizing those instances, 20 years is imposed where a child is forced to act on the adult, and another 10 years is imposed if that recruitment process is within the range of a school. So the point that we're making is the anti-gang legislation does recognize that a child may fall victim to unscrupulous adults, and in those instances, we have to look at it. And then we ask ourselves the question, how does the mandatory minimum of 20 years does not consider or do not consider certain factors such as these, which is why JFJ does not stand in support. So option 1 for us is that mandatory minimum shall not apply to anyone under the age of 18 at the time of committing an offense. And I don't want to go back over all of the points, because I think UNICEF, Jamaica Youth Advocates Network, JAN, the Children's Advocate, and others spoke to the reasoning behind it. The DPP herself, again, though she spoke from a different perspective, the prosecutors, she did recognize in her presentation that there may be instances where a child may be forced to act. So JFJ's position is in keeping with the Conventions of the Rights of the Child and other United Nations principles in dealing with these matters. However, we recognize that should Parliament not accept that option, which is what we are really proposing, we look to other jurisdictions to have a tiered level approach when it comes to child offenders, a range, if you will. And we make mention, for example, in our submission, South Africa, wherein for them, a child who was under the age of 16 when he or she committed the offense, the mandatory minimum is not applied at all. So in other words, it has to be between the bracket of 16 to 18. When we look, Jade, help me, my eyes playing tricks
Let
on
me get that. You're saying, Ms. Jackson, in South Africa, the mandatory minimum does not apply for under 16,
Yes,
but it only applies 16 and 17.
yes.
Okay.
And there are other countries that we...
I think we should note that, yes.
And then when you look at Canada, for example, they have varying levels based on the age brackets. And that's one of the options that we have here that the committee can consider. For example, and I'm going to be going through it. So Canada is one option that we can look at. When we look at the United Kingdom, where a child or someone under the age of 18 is convicted of murder, there is a starting point of 12 years. While those...
So the mandatory minimum is 12?
In UK, which is why we don't support
Okay.
that model. It's 12 years in UK, while those over 18, so in other words, they have a young adult definition in their law, which is something we can replicate. I remember the Children's Advocate cautioning against changing the definition of a child, which we agree because we're signatory to the CRC. But, and I also noted her caution with the Juvenile Justice Act, which is now repealed. So what we were looking at is perhaps how do we consider even a young adult, 18 to 21, as well, because they do also face particular vulnerabilities. So nevertheless, the UK is also another jurisdiction that could be considered. I want to say for even the United Kingdom that has the 12-year mandatory minimum of, there is still judicial discretion. So the judiciary can actually go below the 12 years based on mitigating factors. So in other words, 12 years is the starting point, but it's not closed. The judges can look at the unique circumstances of each case to determine whether or not they go up or down.
Okay.
Just for reference, it's page 7 in the recommendations, recommendation 3.2 that we just referenced.
It's on page 8, right?
7 to 8, yes.
Okay.
All right, so JFJ, our legislative proposal is on page 8. And what we did, again, keeping in context that our first option is that mandatory minimum is not applied to anyone under 18. But should the Joint Select Committee differ on that opinion, our legislative proposal under page 8 could be instructive in terms of how it could be approached, where we look at the age range of the offenders, but we keep the minimums very low still. And again, based on the comment you made earlier, Minister Chuck, and for reference to the other members, when you have aggravating factors at play, then of course the judges would go up. So that is something we're asking the committee to look at as another option as it is so guided. And the reason for us to be very clear as you think through it, the reason for us not supporting the earlier calls of colleagues who we greatly respect, for example, repeat offenders should be the only group. For youth repeat offenders should be the only group that mandatory minimum of 20 years is applied. We can't support that because what it means, one, is that our rehabilitation process would have failed. And if you have a youngster who committed murder very early on and got 20 years, I think we would have to re-examine as a society and look at our criminal justice system. Why, say a 14-year-old commit murder, serve 20 years, and again, that's the minimum, comes out at 30 or 40 and commits murder again. I think we would have to really take a look at our criminal justice system in that regard. So we don't support that call. And I remember, I think it was you, Minister Chuck, who asked that question. I watched the presentations with keen interest. There was another call, for example, that the mandatory minimum is only left up to capital offense. We also do not support that at all without a safety valve. Reason being, and I know there may be differences of opinion against with this, but if you even look at the 1990s when this was being debated, the particular provision of the capital murder that speaks to murder in furtherance of another crime, burglary, and so on. And there was a conversation about the facts of the case and the difficulty of proving certain elements and so. The reality, though, are we saying that if we have a 14-year-old, a 15-year-old, who, for whatever circumstances, may have broken into somebody's house and death results, we're saying that child automatically should get 20 years? Is that the most heinous of crimes? That's a question that the committee would have to ask itself. And to be clear, we're not asking necessarily for a redefinition of capital murder. What we're saying that in circumstances of children, we can't negate what that definition is, and also we can't negate that in some circumstances, even within the context of those definitions of capital murder, a child may be acting under the influence of an adult, as well as that particular situation that I mentioned just now. It may be problematic, and it may not be in keeping with the best interests of the child. And yes, public safety must be considered, but these variables are also important as the Joint Select Committee looks at its options.
Members, any comments or, well, let me ask Ms. Jackson. So you agree that even with children, there should be some minimum. Your position is that under 16, it could be 7, 16, 17, it should be 10 or 12, as the case may be. So you do agree that there should be, even for children. No, let me be very frank. You have various views. For instance, UNICEF don't believe there should be any mandatory minimum. But you're different from them. You're saying...
No, to be clear, we agree with UNICEF. But what JSC has always done, so my point, firstly, we do not agree that mandatory minimum should be applied to children at all.
Yes.
But we understand that the Joint Select Committee may very well not share that position and may come to another conclusion.
The position is, to the best of my knowledge, it is now 10 years, isn't that so? SG, we have mandatory minimum for children now? Under the Child Care and Protection Act?
No.
It's just across the board, the group them. What harm you see?
So 12 to 14, you can get a maximum of 25 years. 14 to 18, you can actually get life imprisonment for children.
Right.
Yes,
That's
but there's
the age
no
bracket,
minimum.
but no minimum.
You know that...
So under the Child Care and Protection Act, if you go to section 78, subsection 5, ages 12 to 14, a child can get up to 25 years. Ages 14 to under 18, you can serve life imprisonment. And the JFJ's position has also even cautioned against that, because the principle of the CRC is that the shortest, what's the language, the shortest time for a child at all, in circumstances where it is allowed, or applicable rather.
I know the Child Care and Protection Act is being reviewed generally, but still we have to treat it in relation to the penalties. And so your position, if we don't accept the position of UNICEF, you would say 7 years for under 16 and 10 or 12 years, 10 years for 16 and 17. Is that my understanding?
The years are there. Jade, if you could just for ease of reference, please.
Yes, so we said that it should be if you are less than 10 years.
This is on page 8, I think.
Yes, page 8, legislative proposal. So if you should not serve a period of less than 10 years if the child is 16 and over, 7 years if the child is 14 to 16. Then there are further recommendations depending on where in the Offences Against the Person Act we're speaking. So to 3.1b, it would be 7 years for a child 16 and over, and not less than 5 for a child 14 to 16. In cases of other offenses. So we went through the entire section 3 of the Offences Against the Person Act, which refers to murder, and spoke to all the circumstances. So there are different recommendations for each circumstance, with the least egregious one being an open recommendation.
Right. Your proposal is just the minimum for any offense,
But
for
to be
the
clear,
really least egregious, but it could be higher for a higher.
absolutely.
Right.
And to be clear, Minister, for avoidance of doubt, what we're saying in every single, the premise of our recommendation is that judicial discretion ought to be maintained or inserted for everything.
No, and I don't think anyone will disagree with that, you see. At the same time, you can't ignore the society's call, and especially the victims and the families of the victims. They don't like when their loved one has been put away, to see the offender not being treated in a manner commensurate with what they've done. I think you appreciate that. So, it is a concern, obviously, for the utilitarian, and you understand what I mean by the utilitarian. They're always looking forward. Forget the past, while the victim and the families of the victims want retribution. They want to be able to see that justice was done, and for them, justice is retribution. But for, human rights organization, people looking forward say, let's move forward a utilitarian approach. But how you balance them is very important. Because if you don't get a balance, then the society will feel that the government or the legislature is not being fair or is not providing justice for, victims of serious offenses. So that is why somewhere along the line, we have to find a balance, and this is where we don't mind you assisting us in making these proposals. All right. Sorry, SG, hello, SG. Press your mic.
Yes.
Go ahead, SG.
Thanks. Through you, Chair. Good morning to the Chair and colleagues and members of the committee. I apologize for being late. Through you, Chair, I would just like to clarify the recommendations on page 8.
Page 6?
On page 8.
Yes.
The recommendations in relation to the amendments proposed, I think, to the Child Care and Protection Act, are they only in relation to the Offences Against the Person Act? I ask because Child Care and Protection Act provides limits as it relates to all offenses, not just murder. It's all offenses. So if this committee, and you have to be cognizant of the remit of this committee. This committee does not have the remit to look at all offenses.
Just murder.
Generally. So again, I'm just asking for clarification about the proposal, if the proposal is only in relation to offenses under the Offences Against the Person Act, and in particular, it seems to only be in relation to Section 3 of the Offences Against the Person Act, and not other offenses in the Offences Against the Person Act. So I just wanted that to be clarified.
Well, it's clear that we're only dealing with homicide. We're not dealing, so, okay?
Yes, and the proposal does speak to it by making
offense
references
against murder.
to the
Okay,
Offences
SG.
Against the Persons Act.
Right. So
But as you deliberate, you could
no. So if the committee is minded to accept this, you're going to now have an inconsistency with the offenses that would be applicable, or the penalties that would be applicable for other offenses that children would commit.
So we have to make that differentiation. Is that so, SG?
No. Well, my submission would be quite different. I think this would require a more detailed review of the Child Care and Protection Act. And you see, it's the Ministry of Justice that is leading this charge, the Child Care and Protection Act.
No, it's education, Ministry of Education.
Okay, there you go.
Okay, Senator.
Mr. Chairman, thank you. Can you hear me?
Just lift it a little
All
bit.
right. Can you tell me, Ms. Jackson, whether in arriving at the recommendations for the levels of custodial sentences, if you took a look at the numbers in relation to child offenders in respect of murder, and can you speak a little bit about that data if you had looked at it, what your findings were?
Well, we looked at a couple things, not just murder, but the firearm offenses, in terms of the number of children who have been charged. And we were minded by the data provided by the CAD in the last sitting, where the data suggested that only 3% of the murder would have been committed by child offenders. And I recall the DPP speaking to the matter as well to indicate that the imposition of sentences perhaps, I think, reached up to about 18 years. I don't want to misquote her, but that was also considered as we reviewed our proposal. But when we were making it, what we also did, in the absence of some of the relevant context data in Jamaica, we simply looked at other jurisdictions as well.
So can you talk about what you see in relation to child offenders? Because the data that you're referring to from the Court Administration Division does not disaggregate the ages between 0 and 17 years. And yet still that cohort is responsible for, as you said, 3% of the persons accused of murder, matters in the court. They're responsible for only 3%. The vast majority are between the ages of 18 to 26, who would not be children, and 27 to 35, 33% for them. So in looking at other countries, what kinds of percentages were you seeing for young child offenders, not young, but for child offenders, for offenses like murder? Is it comparable to what this says? I'm trying to understand. I mean, we were all here at the Joint Select Committee too, so I'm assuming in preparing for this you would have looked more deeply than some of the presentations that we have had.
No, we did not look at the data in that manner as you're requesting it, so I wouldn't be able to answer that question. But it's something, member, we're always open to providing information where so needed, so that a decision could be taken. So we could look at it and provide that data to you, not a problem.
Chairman, I asked the question because I am grappling with it, and I'm grappling with it in a very serious way, because we're seeking to apply a remedy to a problem that represents 3% of the matters in the courts. The vast problem is the 18 to 50 age cohort. And so I must say that I have found the submissions made previously by the children's advocate quite reasoned and persuasive. I'm hearing Jamaicans for Justice. I'm having a little disconnect, and my disconnect is that I'm not understanding why I would be persuaded to this tiered approach, because I'm not understanding the basis on which you're saying it, other than it's just something that sits in between mandatory minimum and none at all. And so I don't know if I could make a request now, and it's not too late. I certainly think I would need it at the end state of the committee. is to ask the Court Administration Division if they would disaggregate this data that they have given us in relation to child offenders, since that is a specific group that we're looking at, and let us know the age ranges that we're talking about, whether it's 0 to 5, 6 to 9, 10 to 12, 12 to 16. I'm just throwing that out randomly. But what's the breakdown in terms of the ages and the level of offenses in the court? I'm cautious, Mr. Chairman. I'm cautious that we may be applying a very serious and drastic, and it's a harsh penalty, make no bones about it, to a cohort that is not actually responsible for the levels of mayhem that we are finding in respect of this offense in the society. And so I want us to be driven by what is actually happening and not, Ms. Jackson, which is my objection to superlatives, not driven by our emotions. So I hope you didn't take any offense, but my hair stand on end when I hear adjectives and superlatives in law. They always do. Because if the point is clear, then it doesn't, there's no need for it to be patently clear.
I think Senator Campbell, you're quite correct. I'll ask the technical team to assist me to just speak with the Court Administration Division or the statistician. We can get that information. In other words, over the last 10, 20 years, how many... Right. So how many cases? I know the beauty about statistics is factual. And the information is available. I know the statistician in the courts, they have gathered and compiled a huge amount of information, but we just want to decipher the figures for the young adults. You see, there's no doubt that once a juvenile has committed an offense, it becomes very prominent, and you get the impression that it is much wider than it actually is. But I think my recollection, we're looking at a figure of about 3%. Yes. Right, a figure of about 3%. And therefore, as you say, Senator Camden, the committee must bear that in mind. We have to use that in terms of formulating. Yeah. Okay, so sorry.
Yeah, what would have been good in that data gathering is if we could define if there are any of those who would have been associated with the influence of other adults.
It's oftentimes we would have to get that information from the DPPs,
from the
officer of
DPP,
the DPP,
right,
who may have some relevant evidence in support.
Because in this case, that is where my mind would have been clearly directed, and attending to and treating with a greater emphasis on those adults who would have influenced any child in committing that offense. And I think that is where this committee may need to apply some attention to.
Yes.
Quite. So we try and get some additional information.
If I may,
go ahead, Ms. Jackson.
Member Chuck, I want to place on record that we do agree with Senator Golding and her comments about the need for data. Let's be very clear, we agree. The place from which we were speaking, Senator, and I'm happy though that while we may not have articulated in a manner that was clear to you and I don't know if any other members, I think we agree that this is a harsh penalty and it must be treated with caution. So when we made the recommendation as a possible way of negotiating a middle ground, it's based on the cognitive development levels of our children. So again, it's already existing law, why I mentioned the 12 to 14, and we broke it down in the possibility of 16 my apologies, 15 and 16, that age group. So another band was broken down within that context. But when you spoke about the need for statistics, we agree, because my bigger question perhaps to the Joint Select Committee, while there is a need to satisfy the public, my question is, how many cases have we seen where the judges have not made a decision that is in keeping with the sentencing guidelines why this committee has been convened in the first place? That is my question to even the purpose of us reviewing it here. Because while the public is making a demand for greater sentencing, you said it earlier, 3%, but the media reports would suggest something otherwise. It's the same question we made even when we were making a presentation before the Joint Select Committee reviewing the bail bill, that you will be having that 1, 2, or 3 cases that are alarming and it makes the headlines. But my question to the Joint Select Committee is, what is the data from the relevant agencies to suggest that the judiciary is not making sentences that are in keeping with the sentencing guidelines and that are not appropriate for the cases?
No, and you're correct, Ms. Jackson. There's no doubt this is where the committee has to take cognizance. And all the presentations, fulsome presentation, and especially for under the Child Care and Protection Act. And we need to look at that carefully so that we don't recommend to the Parliament anything that would really be so outrageous. It has to be appropriate to get a proper balance between the behavior of juveniles and if they do commit murder, is it so widespread that a signal needs to be sent, or are these sort of, unusual cases where we shouldn't make a law for unusual cases? And that is something we have to bear in mind.
But, Chairman, that is why we are having these deliberations.
Quite.
We started from the onset by identifying that there's a high level of murder in the society.
Quite.
And we are seeking to increase the threshold of convictions. But the fact that we're having the deliberations is allowing stakeholders to represent the issues, bring further clarity, so that this committee can make the appropriate determination in what type of sentences we're going to apply. So it's a meaningful discussion and deliberation, and I accept the recommendations in total in terms of the approach and the positions presented by each stakeholder. It's just now for the committee at the appropriate time to determine the outcome.
Sure. You finished?
Yes, thank you so much.
Right. You see, all right. Thanks, Ms. Jackson. I must say, I want to thank you and your organizations for the extensive work you do in making your submissions to Parliament. I certainly did not read everything so far, but I will go through again, to ensure that your work was not in vain, to make sure at least I understand and appreciate what you have been submitted. I think you'll appreciate, even from the outset and the various aims of sentencing, that one of the bases for this, the amendments being put forward by the legislature is the level of murders that have been committed over the last many years. Truth of the matter is that penalties send the signal that certain offenses, here murder, that they must be condemned in the strongest terms. And obviously, if it is not death, the question is the most severe and harsh punishment to send that signal across, the society. But at the same time, as we have recognized, that rainbow of offenses, even for the egregious offense of murder, must be recognized, and therefore we will also look at that. And that is why, the Plea Negotiations Act is useful too for those cases where the offender might have, out of rage and without any strong and long intentional approach to murder, that they can plea for mercy. So these are things that will be taken into consideration. Naturally, the question of children gives us a hard position because we have to look at balancing between what the child has done as against the fact that we're dealing with a young child with a future ahead of them. So these are considerations that the committee will take into consideration. And certainly your presentation, Jamaicans for Justice, is welcome. And we will take everything you have said into consideration. Committee, the position is that this is the last presentation. We will get a matrix has been provided, and we'll ask Ms. Brandon to just update the matrix and circulate it as soon as possible. But we really would like to have another meeting next Tuesday, where we firstly start a discussion, not necessarily conclude, but start the discussion how we make our final decision. We certainly, next Tuesday, members of the committee would like to confirm all the minutes. Next Tuesday at 10. Not possible? What is the date we have? Go ahead.
Look at the date. I wanted to ask you a question. And I think if when we meet back, you could let me know how many times now has the plea bargaining act been used?
It's used quite a lot, you know.
Yeah,
no,
I know at the beginning, I know that it was not used.
No,
when it was just
I'm glad you asked that question, Senator
sir,
Motley.
But sir,
because
quite a lot. I wonder if you have any figures that you could share with us on the next occasion.
And you know, that's very important because since the act was enacted, quite frankly, I think it's very important that we encourage people to plead guilty. Now, a lot of the guilty pleas have been accepted by the DPP's office. And sometimes they don't really negotiate the penalty. They just leave it to the judge, and the judge imposes the sentence, even without any bargaining. They just leave it to the defense counsel to make the point. The important point to note is that plea negotiations is one of the inventions of the American system. And the American system uses it so much that in most states, 95% of the cases are completed by plea negotiations. In most states, less than 5% of the cases are actually tried. The truth of the matter is, sometimes the evidence is so overwhelming that when it is presented to the defense, they really say to their client, it's not in your interest to really go forward because you're going to be convicted. So that they negotiate a guilty plea and then use the guilty plea to negotiate an appropriate sentence. I have encouraged it in Jamaica, though the figures I don't have, but I'm going to try and get the figures from the DPP. But it is something that we must really encourage more. Even in the Firearms Act, when it was being put forward, I urged that it should be there. In the Firearms Act now, it is there, but it is applicable only where the offender gives some additional information that can help the Crown. Okay, so that is in the Firearms Act. In this particular legislation, we hope that at least offenders can plead guilty and then come out of the mandatory minimum, even though if it is egregious, we expect the judge to impose the most severe penalty. Fine. But they are less egregious where, something lesser can be found. So the answer to your question, really, Senator Motley, is that I know it has been used, but we need the figures, and I'm going to try and get them.
Useful, Minister, if we also had the figures under the Criminal Justice Administration Act, so we know which legislation has been more effective in getting the pleas. And when I hear people talk about the Criminal Justice Administration Act, I think they tend to forget that even though there's some kind of formula that a judge, where he or she finds that the case falls outside of that remit, that is to say, it is, to use your words, egregious, that they don't have to apply that formula. So I think that we need a proper analysis of which one really works, and if one is working efficiently, how in fact we can strengthen it. Say, for example, your main concern is the response of the victim. So do we need, if the Criminal Justice Administration Act is working, do we need to look at the aspect of it that would involve the victim in a much more fundamental way in terms of the sentencing?
Well, and that's the point.
And
I think the major point why I would really want the plea bargaining act to be used is that in the act itself, the sentiments of the victims or the victim's family should be taken into consideration. Because I've heard far too many cases who complain to me that the man get 20 years, him should get more, things like that. And when you ask, but were you not consulted? No, me only hear the man get 20 years, and if I was there in court, I would have asked for a longer sentence, something like that. You're with me now? And the judges have applied the Criminal Justice Administration Amendment Act to appropriately. But oftentimes it results in serious complaints from not only the victims, but the society. I give you one which was public knowledge, where the judge applied the act appropriately. The man was charged with murder. He pleaded guilty to manslaughter. It's one in which he had thrown his over the. So the judge started out at a sentence of 18 years, which would be appropriate for manslaughter. Then, because he pleaded guilty just before the trial, the judge took off a third. So it went down to 12 years. But the man had already served 4 or 5 years in custody. So from 12 years, it went down to 8. And the end result was that the person who had charged with murder, pleaded guilty to manslaughter, was sentenced to 8 years. And people are complaining, but the man will be out of the 5 years because, he gets a third. So the point I'm making is that the law was applied properly. But maybe in the plea negotiation, if the man had been sentenced to 12 years, for example, it might have been more satisfactory to both sides. When I spoke to the DPP office, they said, well, the man pleaded guilty. The judge simply applied the law. And nothing was wrong in the application of the law. But I think you may recall that as a case like that. And the people are upset that a most egregious act, that the man might only serve five years. You get me? So the point really I'm making is it overlaps. But I would be more concerned that in the sentencing process, provision is made for the victim and the families of the victim to be considered. And that is why it is outlined clearly in the Plea Negotiation Act that has to be taken into consideration. Not that it is a veto, but it must be taken into consideration.
Last intervention, because I think that part of the difficulty with the Plea Bargain Act is that it requires the defense to make full disclosure, fulsome disclosure. But even in the discussions with the DPP and the defense, the judge does not have to agree. And I think what is missing is a level of trust and confidence about how the disclosures and how everything is treated. So if you could speak to some of the practicing attorneys and find out what is their reluctance in using it. I think it would be quite helpful in determining how it can be fixed to encourage the use.
But I would say sentimentally, I don't know if things have changed, but in my time as a practicing attorney, it's not so much a lawyer. It is the man who feel that him pay you and employ you. You must go fight the case. In other words, am I not right? Oftentimes, well, to the best of my knowledge, my recollection is that when I used to be at the bar, is to explain to the accused, if you go to trial, the likelihood is that you're going to be convicted. You know, but 9 out of 10 of them believe that if you fight the case, he stands a chance, you know. So it is really not so, where I think you're seeing more can be done by the Office of the DPP is to present to defense counsel, this is the case we have against your accused, and if he pleads guilty, we're recommending a sentence of 15 years, 20 years. I don't know if that is now done. No, that is what is done in the United States, where, based on the evidence, they would say to defense counsel, the evidence is so strong, the likelihood is that your client will be convicted. We are recommending, if you plead guilty, a sentence of 25 years. Oftentimes, the accused attorney will come back and say, can you make it 15? And then that's why it is called negotiation. They bargain between 25 and 15. This is where I believe that the Office of the DPP should start something like this. Make an offer. If you plead guilty, we would recommend 30 years. Obviously, the accused is going to say no. You know, in my time, there was one case in which I recommended a guilty plea to the accused. And there were 2 accused. And the accused I was representing say, yes, but beg you, sir, see if you can get a single-digit sentence. I said, I will discuss it with the judge. But the second accused said he would plead guilty too, but only if he's getting a road sentence, which is a suspended. This is murder, and we're going to plead guilty to manslaughter. And I indicated, and the truth of the matter is that I went to the judge, and the judge had indicated, based on the evidence, 8 years, he would consider 8 years. So we were very happy that we would go and get an 8-year sentence. And when the other accused said, only if he is getting a road sentence, that's what they call it, a suspended sentence. Quite frankly, both the other attorney and myself withdrew from the case. This is like late 1980s. Just to show you, sometimes you recommend to your client, but they don't necessarily accept it. There's a recent case, which my daughter told me about. She withdrew too because she recommended, this is a man who burnt up his spouse and killed her, that you plead guilty and to manslaughter, and she was trying to get a 25-year sentence. Said, no. Well, he was convicted, went to trial, was convicted, and the judge sentenced him to life imprisonment with a minimum of 45 years. When if he had pleaded guilty, he may have got, much less a sentence. So, the point about it, the plea negotiation, is something which I've been promoting, and opportunity like this is to tell defense counsel, accused, bargain. It's there. You go, yes, in 1 out of 5 cases, the accused may get off. But in 4 out of 5, if they're convicted, the sentence could be heavy. So, members, we have a job ahead of us, which what did we have? But you start next week, Wednesday at 2 o'clock, is that possible? That's the 27th. All right, let's try for next week, Wednesday at 2. And those who can attend, we want to, first of all, just at least, we're not going to conclude. We're going to just start the discussion. Technical team, next week, Wednesday at 2 o'clock. We start the discussion, and hopefully, at another session or 2, we try and get a final position and a report to Parliament, okay? So next Wednesday at 2 o'clock. Members, thank you very much. And may I have a motion for adjournment? Thanks, Mr.